Mr. Nations, thank you for joining us today. You recently published an article called Bad Actos in Trial Magazine, and in it you talk about the drug and some of its dangers.
Yes, as you know, Actos is a drug that's used to treat diabetes, but it has recently been linked to bladder cancer. In 2011, the FDA issued a warning and required the Actos manufacturer to put on its label the fact that it had been linked to cancer of the bladder in 2 cases, 1 in a large cumulative dose and 2 in use of the drug for more than 1 year.
Warnings. Have there been any other warnings in any other place besides the United States?
In Europe, the French Medicines Agency suspended the use of Actos. In 2011, based on a cohort study there, they linked long-term use of Actos to an increased incidence of bladder cancer.
Now, what do you mean by long-term use?
A year or more.
Now, Actos' manufacturers Takeda Pharmaceuticals. They cite their own study saying that there's no link between Actos and bladder cancer.
Yes, that study in 2005, not surprisingly, was funded by the industry, and it was totally flawed. They purposely excluded from the study groups of patients based upon latency periods of cancer and patient risk factors.
Latency periods?
The latency period between exposure to a carcinogen and the development of transitional cell carcinoma, the most common form of bladder cancer, is between 9 months and 23 years. The Takeda study excluded cancer patients whose tumors occurred within 1 year.
And then the risk factors?
Yes, also excluded those patients with known risk factors, those who smoked, were exposed to potential carcinogens, had a family history of bladder cancer, previous tumor or urinary tract infection.
So a bunch of people.
It skewed the results considerably. And then in 2009, having studied their data again, Takeda researchers actually came back and claimed that Actos actually helps inhibit the growth of cancer.
So the pharmaceutical company's conclusions are completely contrary to the independent reviews of the same drug.
That's correct. Independent researchers went back and evaluated the Takeda study, the data from that study, and they reported in Lancet, which is a highly respected journal out of Britain, a significant relation between Actos and bladder cancer that had not been presented in the industry-funded study. Quote, "This finding, associated with the preclinical and clinical findings reported on the FDA website in 2004, could have led to an alert 5 years earlier."
So more people were exposed then to the risk of bladder cancer from taking Actos long-term?
Correct.
Due to a lack of warning?
Yes.
For those people who took Actos for more than a year and subsequently developed bladder cancer, those people are involved as plaintiffs in lawsuits against Takeda, the manufacturer?
Yes, but when you're in a lawsuit of this type, it gets placed into an MDL, multi-district litigation, so that every case in the country that's filed in state court is moved into federal court. They're all moved into one court before one judge. With Actos, it's in Louisiana.
Is it important for a plaintiff to pick an attorney who is a pharmaceutical specialist when you consider who the defendant is?
Yes, absolutely, because when the pharmaceutical companies hire their lawyers, they pick lawyers who specialize in pharmaceutical litigation. And the pharmaceutical litigation, both from the plaintiff side and the defense side, is really a very small community of lawyers. The same defense lawyers defend cases over and over. The same plaintiff's lawyers prosecute cases over and over in all types of multi-district litigation. The same judges end up with the cases over and over. So it's important, if you're going to be heard, that your lawyer be known to the defense lawyers, to the judge, to the plaintiff steering committee members, to everyone else in the litigation. Because you could hire the finest local lawyer you can find, but when they get to the multi-district litigation site, they'll be completely lost and they won't have a voice.
As a pharmaceutical litigation specialist in this Actos litigation, what are some things that you consider when deciding on the value of a case?
Well, the first thing we have to establish is responsibility or liability on the part of Takeda for the injury to this particular plaintiff. In order to do that, you have to establish the amount of Actos that was actually taken, consumed by the plaintiff over what period of time, and what was the amount of time between the taking of the Actos and the duration of the taking of the Actos and the onset of bladder cancer. There are all sorts of pharmaceutical and medical questions that arise, a different set with each particular drug. And what we look at, once we establish that yes, they did take Actos, they took it within the relevant time frame, they took a sufficient amount, we're still going to be confronted with the defenses that are going to be raised by the other side. So you may reduce the damages that you recover when you have strong comorbidities against you, but that doesn't mean that you just say, okay, fine, we'll go away. This is not a valid claim.
Now back to the article, Bad Actos, you discuss in it the etiology of bladder cancer.
Yes, it's important to understand this. In our bodies, the bladders are vulnerable to the adverse effects of drugs because carcinogens in the urine can be stored for a prolonged period of time close to the cellular lining of the organ. And that can lead to bladder cancer, of which there are 4 different types: transitional cell carcinoma, squamous cell carcinoma, adenocarcinoma, and small cell carcinoma.
And extended use of Actos can cause all 4 of these types of bladder cancer?
Extended use of Actos has been linked to all 4 types of bladder cancer.
And in the article, you also cite some interesting demographics as they relate to bladder cancer. For instance, it's the 7th most common type of cancer in men worldwide. And in men, it's 3 to 4 times more prevalent than in women. Well, age is also a factor. 90% of new cases reported occur in people over 55 years of age. And Caucasians are twice as likely to contract bladder cancer as other demographics such as African Americans, Asian Americans, Hispanics, and Native Americans.
So for example, let's say you're a 70-year-old white man with bladder cancer who was prescribed Actos for more than a year. Since there could be additional risk factors or comorbidities, such as age, sex, or race, in this instance, there's what is known as comparative causation of damages.
So let's take a closer look at the risk factors other than prolonged Actos exposure. I believe smoking is a risk factor, as we discussed earlier.
Smoking is clearly the most important risk factor as it relates to bladder cancer. And lawyers reject cases where Actos users for more than a year were also lifelong smokers. But let's consider for a moment the case of a 50-year-old woman who smoked for 10 years with no bladder cancer. And after 18 months of taking Actos, she's diagnosed.
So Actos exposure was a causative factor.
Yes, it's a causative factor, but I think lawyers are placing too much emphasis on the smoking aspect of this case, because we're taking cases where many times someone may have smoked who's 60 years old now. They smoked from the time they were 20 to 40, and they quit smoking when they were 40, but they were a 20-year smoker. But it's been 20 years since they smoked, and now they use Actos for 12, 13, 14 months, and they come down with bladder cancer. The fact that they smoked for 20 years is not going to keep us from taking that case. Also, even closer, someone who smokes up until 2 years ago and they just quit, and now they start taking Actos, now they have bladder cancer. I think that is a diminution of the value. That is comparative fault at that point, but it is not a total defense to come in and say that they were smoking at some point in their life, so now this didn't have anything to do with causing their bladder cancer. You're dealing with 2 separate causes of bladder cancer, smoking and Actos. And when those 2 things are co-joined, then it's a comparative fault situation, not a complete defense.
So does the same hold true for individuals who are current smokers?
It doesn't. We're not taking cases where the diagnosis of bladder cancer occurs after someone's been using Actos for a considerable period of time, but they've been smoking the whole time and they continue to smoke at this time. That's too big a burden to carry, so we simply are not taking those cases.
And what about comorbidities?
Most Actos patients suffer from diabetes, and epidemiological studies suggest an increased risk of bladder cancer as a result of having diabetes. Takeda obviously knew that the people who were using this had diabetes because that's what it was given to treat. Yet they failed to warn that diabetes may be a comorbid condition that would lead to bladder cancer.
And I saw in the article that there were other comorbidities: family history of bladder cancer, or personal history of urinary infections, kidney stones, bladder irritations from other causes, and even tumor in the urinary tract.
Any of these, Takeda can use to defend its product. And they blame the user's health and not their drug for causing bladder cancer.
Then, as I read in the article, in each case a causation analysis needs to be performed?
Yes. In 1964, the landmark U.S. Surgeon General's report on smoking and health established the criteria to distinguish between causal and non-causal associations in environment and disease analysis. The following year, Sir Bradford Hill, a British epidemiologist and statistician, listed 9 criteria that are commonly followed worldwide in epidemiological community in causation analysis. Strength of association. Studies indicate an increased risk of bladder cancer from prolonged exposure to Actos. Consistency. Each Actos study found an increased risk of bladder cancer. Specificity. Actos has been linked to bladder cancer and no other type. Temporality. Exposure must predate the disease. Actos exposure must have occurred 1 year prior to the diagnosis of bladder cancer. And let me say at that point that the study that showed 1 year was chosen as a totally arbitrary date. We're taking cases where there was 6 months of use, because there's absolutely nothing that establishes that it can't happen in 6 months, 9 months. The idea of 1 year is something that came actually from Takeda.
So prolonged use is an arbitrary term.
And there's another thing you look at, which is the next element that Sir Bradford Hill raised, which is biological gradient. Studies have been shown consistently that the risk of bladder cancer increases substantially with cumulative Actos dosages of 28,000 milligrams. So with every patient, we get their prescriptions for the entire time that they took Actos, and we add up total the number of milligrams that they actually took. And it doesn't have to be to 28,000 milligrams. You can develop bladder cancer without reaching the 28,000 milligram mark. But if you took it for 9 months, and during that 9 month period, you consumed 28,000 milligrams of Actos, the fact that it hasn't been a year is not going to stop you from prosecuting that case successfully. If you had 28,000 milligrams of Actos in a 6, 8, 9 month period, that's a good valid claim against Actos for causing bladder cancer. The next element was biological plausibility, and that is that no other oral agent associated with increased bladder cancer risk and no increased risk of other cancers in Actos uses support the biological plausibility of the causal connection to bladder cancer. The next is coherence. What has been discovered with Actos and the link to bladder cancer does not conflict with what is known about the biology of bladder disease. The next is experimental evidence. Laboratory testing supports the Actos bladder cancer connection. And then analogy. The medical literature is replete with studies linking Actos and bladder cancer.
Is this like a class action?
No, it's not. In a class action, the plaintiffs are all lumped together, they're put into a grid, and the people in that grid will receive the same amount of money for the same type of injury. The big advantage of multi-district litigation over a class action is in multi-district litigation, when your individual case is filed, it's moved into one court along with all the other cases in the country. And then there's a team of usually 10 to 12 lawyers who are appointed by the judge, whose job it is to establish responsibility or liability of the defendant for causing, in this case, the bladder cancer. Now, for an individual plaintiff to try to spend the amount of money it would take to successfully prove that Takeda knew or should have known, or that they faked their studies, that type of thing would cost hundreds of thousands, if not millions of dollars, literally, to prosecute a case of that type. And to do that on behalf of one plaintiff would not be economically feasible. So when you're joined together with maybe 10,000 or 20,000 other plaintiffs, now all of those people are contributing to the prosecution of the case. So you share the expenses on a pro rata basis. So it comes down to possibly a few hundred or maybe even $1,000 for your individual prosecution of the case, and for that you're establishing liability of the defendant. Now once liability is successfully established, the responsibility of Takeda for the damages arising out of the bladder cancer, now this is where the big advantage of the MDL over the class action really takes place, because now we look at your case individually. We don't lump you into a grid. We take your individual bladder cancer case. We get your medical records, we review your medical records, we put together a negotiation package, we meet with the defendant, we negotiate your case, we present it, we mediate it, and we negotiate your specific case for the value for settlement purposes of your case. If the case settles, fine. If it doesn't, it may have to go back and be sent back to your home district for trial. That's most unlikely in MDL litigation. But the whole point is the two advantages. Number one, your expenses are very low and you can afford to prosecute the claim because you're sharing expenses with thousands of other people. But number two, you still maintain your individual value and evaluation and mediation and presentation of your individual case.
What is the likelihood that a case would go to trial?
The likelihood of a case going to trial in an MDL is that maybe 3 or 4 cases out of 20,000. If you're in a 20 or 30,000 case, as for example in Zyprexa, we had 32,000 plaintiffs. In Zyprexa, none of the cases ever went to trial. But you choose a bellwether case, and that bellwether case is tried in the court where they're all assigned. In that bellwether case, the idea is to give you some indication of what these cases are worth.
So if there was an attorney watching this program, or even a patient who's been diagnosed with bladder cancer after taking Actos, and they watch this program, what do you suggest they should do?
Well, this is a very specialized area of law, very specialized area of trial practice, and it's a specialized area of medicine and pharmaceuticals. So at this point, you would have to put the case into the hands of someone who is finely tuned to what is currently going on in the Actos litigation, because it's been going on for quite some time now. My firm has been in the Actos litigation from the beginning. We have a very large number of Actos bladder cancer cases that we're currently prosecuting actively, and we'd be glad to talk to either a lawyer or an individual plaintiff who has an Actos case. But whatever you do, whether you call our firm or not, you really need to get your case into the hands of a pharmaceutical specialist. But call us at 1-800-269-3050, and we have several lawyers who are working on the Actos litigation, and I'll be glad to talk to you, or one of our lawyers will be glad to talk to you and answer all the questions for you free of charge.